A very good morning, Kenyans, members of the public and beloved citizens. My name is Abner Collins Mango, Advocate of the High Court of Kenya, of 5 years standing in my practice. I practice in the firm of Bikagunyi and Company Advocates as partner, and I also happen to serve as a member of the Public Interest Litigation Committee of the Law Society of Kenya. The Law Society of Kenya is an institution, a society created by dint of the Law Society of Kenya Act. This act establishes the society under Section 3 of the said act, which makes it a body that is capable of being sued and suing and being sued. But more importantly is Section 4 of the act that gives this society its different objects as regards the rule of law in the country. Specifically, Section 4A grants the LSK the mandate to assist the government, and not only the government and the courts, in the administration of justice and the protection of the rule of law. 4B also gives the LSK the mandate to uphold the Constitution of Kenya and the rule of law. And C, Part D, also mandates the Law Society of Kenya to assist members of the general public to be able to access justice and ensure that justice is effectively administered. Section 6 of the said act as well gives the LSK its function under the establishment and under the objects. This still includes protection of the rule of law, promoting public interests in matters concerning the rule of law, and as well as assisting also the members of the public in doing the same. It is by these very this statute and functions that Kenyans have most recently seen the Law Society of Kenya being active in matters rule of law and public interest. Now, whoever who's been around the country, especially since last year, as a country we have experienced a lot of actions or omissions that have led to great breaches of what would term as human rights. Now, the Kenyan Constitution under Chapter 4 establishes the Bill of Rights that guarantees Kenyans a lot of rights and a variety of rights. These rights include rights as basic, such as the right to life, right to access medical care, rights to have the best standards of living, right to live in a clean environment, and also protections, right to own property, freedom of speech, freedom of association, and all these Kenyans are supposed to enjoy under the new constitution, or the Kenyan Constitution that was promulgated in the year 2010. However, in the past few years, we have seen a lot of breaches or disregards of this right. And this is a direct threat to the rule of law, the Constitution of Kenya, and the people of Kenya as well. Now, Article 1 of the Constitution gives all sovereign power to the people of Kenya, who, when they promulgated the Kenyan Constitution 2010, meant to be governed by the Kenyan Constitution. Now, some of the actions that we have seen, especially things to do with Article 37, for example, which gives Kenyans the right to assemble. We have seen a lot of demonstrations, and especially since last year, that have been dubbed the Gen Z demonstrations. And these demonstrations was generally a call to the government to, one, good governance. There was a lot of wastage and pilferage of public funds. There was incidents like corruption, massive corruption, and extrajudicial killings. And all these are things that Kenyans wanted addressed by those in power, especially the executive. Now, upon Kenyans feeling that they were oppressed, especially with the enactment of the finance bill last year, that is what called the Kenyans to hit the streets and demonstrate. And that saw a very dark period in time in our country where we lost a number of patriots who had democratically gone to the street to exercise their right to picket and demonstrate and fight for their rights. So part of public interest litigation is to ensure that, one, the rule of law is upheld, but as well as social justice is upheld. Now, social justice is to ensure that certain fundamental rights and freedoms are not curtailed and or people are not oppressed. For example, your right to liberty. Article 49 as well, the rights of an arrested person. If you are arrested for whatever reason, you are supposed to be arraigned before a court of law within 24 hours. But we have seen very, very sad circumstances where patriots and Kenyans are either detained unlawfully, to their cases of enforced disappearances, and this was especially seen towards the last bit of the year 2024, where several young Kenyans were abducted. The period ending the year 2024 saw a very dark stage in the country, where several cases of abductions of young citizens were reported all over the country. This was as a result of open dissent and divergent views criticizing the government of the day. However, these young men and patriots were abducted and their disappearances were enforced, and this led to huge public outcry as to the very safety of the citizen. Now, this is part of what forms the public interest litigation, which forms the functions and objects of the society, which includes enforcement of these human rights and protection of the Constitution. Now, some of these unconstitutional acts, if not checked, can lead to anarchy and or the rule of law totally being scattered. Now, this called for action from various stakeholders, that includes the Law Society of Kenya, to move with speed and put to task the government in terms of filing various habeas corpus applications seeking the release of these young Kenyans who were abducted at different regions of the country. Now, the law provides that any arrested person under Article 49 should be presented before a court of law within 24 hours. Now, this brings into action Article 51, which provides for a right to fair hearing. So, for whatever crime or omission that you are suspected to have done, then you are supposed to be presented before a court of law within 24 hours so that you can answer to those charges, rather than being kept incommunicado, in isolation, and experiencing acts of torture and inhumane treatment. Now, some of the narratives and tales that have been told by those who reappeared since the abduction are very worrying tales. These are tales where you find that the citizens narrate of their ordeals, that they were tortured, they were being whipped, they were stripped naked. All these are a gross violation of human rights, not only in Kenya, even under the United Nations Declaration on Human Rights, is a gross violation of human rights. Remember, there are certain rights that are non-derogable and cannot be limited under Article 29 of this Constitution. This includes right from torture, slavery, and inhumane treatment, so that every human being ought to be treated with dignity. So, part of the reason why the Law Society of Kenya has been active to respond to these cases is, one, to maintain constitutionalism, because it is the belief that it is only the law and by the rule of law that a country can be governed and things can operate. Now, a flashback to, for example, the year 2007, Kenya almost fell into an anarchy, and Kenyans themselves have admitted that were it not for institutions, the strengthening of institutions such as judiciary, which now serves as the last hope of Kenyans, then some of these excesses will remain unchecked. And part of the mandate of the society is to not only assist the government in coming up with legislation, but also to check. This also extends to the judiciary, which stands as the last port of call when it comes to the protection of these rights. Remember that the law is not only meant for the rich, but it's also supposed to serve not only the high and mighty, but even the ordinary mwananchi, who in Kenya we term as Wanjiko. All of them should be deemed the same and served the same under the law, so that all rights are equal and are meant to be enjoyed. Now, flash forward to the recent occurrences. For example, now a person has been arrested, has been placed in lawful custody, but due to police excesses, a person happens to pass on while in custody. And this I'm referring to the latest case of the late Albert Ojwang, who died in the hands of the police service or police officers who were meant to protect him while in custody as he awaits his day in court. The parents innocently surrendered their child to the police service with the honest belief that whatever allegations that have been fronted against him, he would be able to answer to them in a court of law. Unfortunately, this son, this father, passed on while in police custody, and the same is now subject to judicial proceedings, where several police officers have subsequently taken plea, and we await that the wheels of justice will move and the family of the late Albert Ojwang will indeed get justice for their son. But more importantly, and that is why there is reason for LSK under the mandate given under Section 6 and 4 and 6 of the LSK Act, is to ensure that the state and non-state actors work together in a way that we ensure that public interest, one, is safeguarded, the public confidence in the judicial system and the laws of the countries are upheld, so that Kenyans are not left with no option but to want to rule themselves, for lack of a better word, because they do no longer have any belief in the institutions set up in Kenya. We have had calls for, bodies, independent bodies such as IPOA, to move with speed and expedite hearing of such cases. So we also need the strengthening of such institutions, so that all together as actors, then we are able to ensure that justice is not only deemed to be served, but it is served. So for purposes of generally protecting public interest, rule of law, and ensuring that there is also development of law and as well as legislation in the country, by dint of Section 4 and 6 of the LSK Act, then the Law Society of Kenya under the Public Interest Litigation Committee are mandated to ensure that the government is kept in check. There are no excesses. Constitutional rights are guaranteed, such as right to liberty, right to property, right even of movement, freedom of speech. In as much as somebody says whatever you do not like, that does not attract criminal sanctions, for example. So if only Kenyans are able to abide, and not only Kenyans, but also the government organs, that is through the legislature, the judiciary, and the executive, then that is only when we can be able to uphold the very constitution we hold dearly, that is the Kenya Constitution 2010, to be able to serve all and sundry. Thank you very much.